Dr. Bukola Saraki had raised some fundamental areas of the law in his appeal before the Supreme Court, which, in his contemplation, should invalidate his trial by the Code of Conduct Tribunal on the charge of false declaration of assets. He said at the time of his arraignment, there was no sitting Attorney General of the Federation and that the tribunal had only one member sitting with the chairman. He also appealed against the warrant of arrest which was issued by the tribunal on him, claiming that the tribunal had no criminal jurisdiction to do so. To all these issues, the Supreme Court determined them against the Senate President, saying that the Code of Conduct Tribunal was a court that needed quasi-criminal authority to be able to do its job effectively. Justice Walter Onogen, in the lead judgment, which was unanimously upheld by the other 6 justices, including the Chief Justice of Nigeria, said the tribunal was properly constituted and had the right quorum.
Controversy surrounding some of the provisions of the Constitution by this judgment have been laid to rest.
The Supreme Court has demonstrated today that the law is the king and not persons.
There are people who say that any average lawyer should be happy today because our law has been developed. What do you think?
I share the same view with them. Our jurisprudence have been expanded. The only case we had before now is the case of Darie versus CCT and Omishere versus CCT. Today's Supreme Court judgment on those issues that we appeal against have led to rest certain interpretation.
With this judgment, the Code of Conduct Tribunal will now set a date for the continuation of trial. There are various ways of looking at this judgment, but one way that would cut across is that Nigeria's law is richer for it with the position of the Supreme Court, as stated by this judgment. From the Supreme Court, Femi Okeowo, NTA News.